Hello and welcome to our last webinar of LD Month. We'll get started in just a minute here. I'm seeing all the attendees coming into the room. Just a few housekeeping things in the beginning. We will have time for questions and answers at the end of this webinar. What you're going to do is if you're on the computer, you're going to hit the Q&A at the bottom. There's a Q&A button. Please submit your questions through the Q&A and not the chat. If you are on the phone, please hit *9 to raise your hand. Once you've raised your hand, I will see that at the end and I will unmute you by calling out your area code. Please make sure that if you've raised your hand, that you're not on speakerphone when we unmute you, because that causes some serious feedback. And we will take your questions there. You can ask them live. And if we do run out of time for questions and answers, there will be contact information on the last slide. There will also be the ability to send us an email with questions at info@ldamerica.org, and we'll be happy to get those to the right people and get you an answer. And with that, I would like to introduce Julia Frost, Chair of our Adult Topics Committee.
Hi everyone, we're very excited to have you involved in this webinar with us. After participating in the webinar, if you want to learn more, I encourage you to join us in Orlando, February 17th through 20th for our annual conference. There will be sessions on adult topics throughout the conference. One of special interest is the Adult Topics Workshop on February 19th, entitled What Employers Expect from Their Employees with LD. We will have HR personnel from AT&T and Marriott discussing their experiences in working with individuals with learning disabilities. You can register on the LD website at ldamerica.org/conference. I'm so excited today to be partnering with the Southwest ADA Center on this webinar. They have experienced personnel with knowledge on this topic and graciously agreed to share with us. Marissa DeMaia, the Deputy Director of the Southwest ADA Center, is running our slides today. And Sashi Kala Nisankaro is their ADA specialist, who is our presenter. So Sashi, thank you so much. We look forward to this.
Thank you so much, Julia. All right, we're ready to get started? Cool. My name is Sashi Nisankaro. I have been now with the ADA Center, with the Southwest ADA Center, for a couple of years. I wanted to thank Julia and Erica for coordinating this, and for Marissa for running my slides and helping me put together this presentation. Today we're just going to discuss everything you need to know about the ADA and employment. There is a lot to cover, and you know, we have a limited amount of time, so before we get started, I did want to point out that the Southwest ADA Center is here in the southwestern region of the country. So we cover Texas, Oklahoma, Louisiana, Arkansas, and New Mexico. There are 9 other ADA centers around the country that cover different regions. Depending on where you live, you will be in touch with your respective ADA center. And the way you get in touch with us is by calling 1-800-949-4232. And we'll show you again at the end of the presentation the phone number. But if you ever have any questions, disability-related issues, questions about your rights or your obligations, we are a neutral entity that answers questions. We'll give you information. We also do trainings on site and webinars like this. So let's go ahead and get started with everything we need to know about the ADA and employment. Next slide, please. Okay, so we just have a disclaimer here. I happen to be a lawyer, but I am not anyone's particular lawyer. Here at the Southwest ADA Center, we do not give legal advice. We merely inform our consumers about their rights and what options they have. So it's just something to keep in mind as we move through this. Next slide, please. Okay, so the ADA in a nutshell, this is going to cover the ADA, the Americans with Disabilities Act, in a very broad, little snippet here. But It's just to prevent discrimination on the basis of disability, and it is the first comprehensive law that covers all different aspects of our everyday life, and you'll see that in the next slide. Okay, so here we're just kind of looking at the 5 titles of the ADA. So the first one is the one that we're talking about today, Title I, Employment. Title II, we're talking about state and local government entities. Title III, we're talking about public accommodations, businesses, hotels, things like that. Title IV, we're talking about telecommunications, and Title V is discussing, miscellaneous topics like legal remedies. But today we're going to focus on employment, which is Title I. Next slide, please.
Sashi, could I get you to speak up just a little bit?
Sure.
Thank you.
Sorry, can you hear me now?
Much better.
Okay, it might be my volume on my mic. Okay, thank you. Okay, so when we get into the scope of Title I, right, what kinds of employers are covered, right? And so we're talking about private entities with 15 or more employees. And then Title I also applies to state and local governments, all state and local governments, regardless of how many employees they have. Depending on the state you live in, you might have a state civil rights or disability rights law that actually brings this number with the private entities down, because state laws are there to fill in the gaps that federal laws leave purposefully. So you might want to look into that depending on where you're tuning in from to figure out what kind of state protections people with disabilities have. Next slide, please. So what's the intent of Title I of the ADA? Like we kind of touched on in the first slide, it's to prohibit against discrimination of qualified individuals with disabilities. And it's to give qualified individuals with disabilities equal access, right, to all the different stages of employment. So that's going to be all the way from applying for a job, interviewing for a job, any kinds of different steps you have to take before you become an employee there, all the way through the course of the employment, through benefits administration, through performance evaluations, performance standards, things like that, all the way through retirement, all the way through even termination sometimes. So it's a very sort of all-encompassing word when we say employment, but what we really mean is just it's the entire life of somebody's job position somewhere. Next slide. Okay, so another federal law we should discuss, and this sort of predates the ADA. So the ADA was passed in 1990, and the Rehabilitation Act was passed in the late 70s. And it's another federal law basically prohibiting discrimination based on disability, and applies to entities that receive federal funding. So a lot of times this is going to be state and local governments, but it could also be grant-funded projects. It could be nonprofit. It kind of depends on where the funding is coming from. Next slide. Okay, so what is the definition of disability? This is important because we do get a lot of calls from people saying, am I covered? Do I have a disability? Do I need to receive Social Security benefits in order to qualify as somebody with a disability under the ADA? And the answer to that Social Security question is no. So you don't actually have to receive disability benefits or Social Security benefits to have a disability under the ADA. The ADA's definition is sort of intentionally broad, and that is to take some of the onus off of the people with the disability from having to prove that they have a disability. So it's having a physical or mental impairment that substantially limits one or more major life activities, right? And so we'll get into what kinds of impairments are covered and then what major life activities are. The second definition is having a record of such an impairment. And then the third definition is being regarded as having such an impairment. We'll get into what these last two definitions mean in just a little bit. Next slide. So the Amendments Act came in around 2008, so about 18 years after the ADA was passed, and this was in response to courts sort of really honing in on whether somebody has a disability and not focusing more on how that disability or how that impairment is limiting somebody. And so, you know, when we say substantially limited, it you know, basically is to show you that you're not really focusing on what the person, like you're not considering like mitigating, you know, factors like whether somebody uses a wheelchair or something, and you're not focusing so much on the diagnosis or something like that. You're focusing on how the person's impacted by the disability. And it, you know, it definitely needs to be more than just, you know, something that's episodic or just infrequently occurring or something like that. But still, it's meant not to be a high threshold, right? It's meant to be something that most people actually could be considered to have a disability, as we look at some of the different kinds of impairments a little bit later on. Let's go to the next slide. Okay, so what's a major life activity, right? This is just going to be anything that you know, that you would do in your daily life, right? And we'll see. Actually, you know what? Let's go to the next slide. I think we have some examples. Yeah. So we just have kind of a non-exhaustive list of major life activities. But you can see it's pretty much anything that you would do on a daily basis, right? So if you have an impairment that really limits, that significantly limits just even one of these, right, then you may have a disability under the ADA. So this is just to show you that a lot more people would have coverage under the ADA, or would have protections under the ADA than they probably think they do. Next slide, please. Okay. So here we're talking about just some impairments that could be, you know, impairments covered under the ADA. So, you know, I think some of these are going to be more obvious and readily thought of, right? For people just kind of learning about this, but you might not think of other things, right? Like major depression disorder or things like that, or major depressive disorder. So there are some more obvious impairments, and then there are obviously the hidden impairments, which is relevant to what you know, who our audience here is today, and that's the learning disability community. Next slide. Okay. So let's talk kind of about those last two definitions that we had of the definition of disability, right? So a record of impairment is, you know, a record of disability is going to be like somebody who maybe had cancer and is now in recession, right? In remission. Sorry about that. So it's early. So, you know, it's their disability is recurring and might actually, they might end up having to be treated for cancer at some point in the future, and they might have received treatment in the past for cancer, but right now they're in remission. Well, that doesn't mean that they are not protected under the ADA just because they're in remission. So, you know, that's where we have that, the record of definition. Then when we talk about the regarded as definition, this is kind of where we're talking about people's perceptions of somebody and whether they appear to have a disability. And, you know, there's no, there's not like, these two definitions are kind of similar in that we're looking at how the disability presents itself. So it's just something to keep in mind. But most of the time, people will fall into one of these categories, if not, more than one. So next slide, please. Okay. So now we're going to actually switch gears and focus on employment specifically, right? So we're talking about the hiring process. The hiring process must be made accessible, right? And this is important because I think people sometimes are afraid to disclose whether they have a disability because they don't think that even applying for the job would be possible without having accommodations. But it's important to know that if you even are applying for a job, that if you request accommodations, they need to be provided, at least reasonable accommodations need to be provided. At this initial hiring stage, no inquiry into whether somebody has a disability can be made, right? So during the screening, recruitment, and hiring process, no disability-related inquiries can be made, which means that they won't be able to request any kinds of medical documentation or anything like that. And that's important because if you do go out and apply for a job or you are interviewing candidates and make these inquiries, if you make them voluntary, that might be a better approach than to require that or to condition someone's employment on whether they can prove that they have a disability at that first stage. This is especially important because most disabilities are going to be hidden disabilities, right? So most of the things that people deal with in terms of health concerns, right, are going to be non-obvious. Things like diabetes or having heart issues or having mental health impairments and things like that. Those are not readily available, visible to people. So it's important that we be, I guess the word would be empathetic, but also stay within, these legal bounds of the ADA and not make the inquiry before, during this hiring process until someone has disclosed that to you in the process. Next slide, please. So now we're kind of moving forward in the employment process, and now we're at the point where an offer has been made, but employment hasn't begun yet. So here you can see that some medical inquiry can be made, into whether someone has a disability, right? And so it's because you made that offer here, so it would make sense that you would inquire a little bit about someone's medical history or someone's disability. But the way that employers need to do this is they need to do it in an even-handed way. So whatever you're going to ask one employee to provide you before they begin employment, you need to ask all the employees to do the same. And this is just to prevent even the appearance that the employer is, has different procedures or different policies in place for some people and not other people. So let's say that an employer makes this inquiry, and then it turns out with the results of the inquiry that somebody has a disability. Do they have to continue with the employment, and do they have to have this person come on and be an employee with them? The answer is no, but if they decide that this person is not qualified to do the job, then what they need to do is they need to make sure that the withdrawal of this person's name from the employment recruiting process is consistent with business necessity, right? So is it consistent with the way that the employer does business, and is it well documented? Those are all things that you need to consider. And then also you need to show that no reasonable accommodation could be made for this person. And the way that you get at the heart of that is think about whether whatever information you got after this disability inquiry shows that the person is or is not qualified to do that particular job. So that's going to be something to think about. But also, you know, think about whether you could accommodate this person, whether you could reassign them to a different position because they would be qualified to do that position instead. These are all considerations that you need to make, and they're all things that you need to document just for, you know, for the employer to do their due diligence. Next slide, please. Okay, so now we are at the stage where work has begun. And this is, if you think about what a reasonable accommodation is, right? It's just going to be any change in the work environment that allows somebody with a disability to, you know, do their job effectively, right? And so, as we mentioned earlier, accommodations apply at all the stages of employment, right? And so there's not a magic point in an employment process where accommodations are triggered. And then, you know, the important thing to remember about accommodations is that they are determined through the interactive process, which we'll talk more about a little bit later on in the presentation. Let's go on to the next slide. Okay, so, you know, this is actually a very salient topic for the learning disability community, is how and when do you decide that you want to disclose that you have a disability to your employer, right? If you saw a few slides ago, we noted that the decision to disclose is always with the person who has the disability. And anytime, you know, you feel like that that right was taken away from you, you know, that could be considered, you know, some kind of discriminatory practice, or, you know, something like that, that you might consider reaching out to the employer about and saying that was improper. Because really the only person who should be making these disclosures is the person with the disability. And, you know, like we mentioned earlier on, there's a stigma, you know, and you might worry that you'll be viewed in a different light by your colleagues or by your superiors. And it's just, you know, these are all things that weigh on us when we're thinking about whether we want to disclose a disability. You know, some of the advantages to disclosing whether you have a disability is that, you know, you'll be sort of right out the gate, right, or as soon as possible, you'll be working with your employer to ensure that you guys are all on the same page and that you're getting either the technology or the procedures in place at work that will enable you to do your job, right? And, you know, you're still qualified to do your job, and you have been. It's just that you need that that tool to continue to do your job effectively. That's the way to think about it, is that these accommodations are not saying that you are not qualified. In fact, they're saying the exact opposite. They're saying that you are qualified and that you're just using these pieces of technology or these procedures and policies to just be even more effective at what you do for a living. Next slide. Okay. So what's a reasonable accommodation? This is kind of like referring back to what we saw a couple slides ago, but it's basically any change in the workplace environment or any change in policy or procedures that's going to allow somebody to do their job more effectively. You'll see that it can run the gamut, right? Accommodations can be something that's pretty simple and run of the mill, and then accommodations can be a little bit more complex. So if we move to the next slide, okay, these are some examples of accommodations, right? So you'll see that it could sort of really run the gamut, right? Change in work location, you can modify your work schedule, reassignment. I mean, there's just a whole host of different, different accommodations. Elimination of marginal job functions. This is a really good one, because if there's something that because of your disability you cannot do, but it's not a huge part of your job description and it's just something you do every now and then, that might be an accommodation that you request. Now, when it comes to the more essential tasks that you have to do for your job, those are not going to be considered to be reasonable in terms of like removing them from your workload. So that's a conversation that you need to have between the employer and the employee about, you know, what are some of the things that you don't really need to be doing as part of your job that we can eliminate or minimize. Next slide. Okay, so who can get accommodated? So this is going to be applicants, of course. This is going to be full-time and part-time employees, seasonal workers. So we're coming up on the holiday season, and there's probably going to be a lot of seasonal and temporary workers. You certainly can be accommodated under the ADA, right? And you would just, as long as you are qualified and you have some kind of impairment that limits your ability to do something, then you are going to have these protections under the ADA. So next slide. Okay. So how's the accommodations process triggered, right? So just yesterday, actually, I had someone ask me, you know, does it have to be in writing? And I said, no. So initially, when you are making a request for accommodations, it doesn't have to be in writing. In fact, it could be something kind of more relaxed, where you're just in the break room and your manager happens to be there and you're eating lunch and you say, you know what, I've been having trouble doing this, or I can't seem to focus on this, or I need help with this. Those are considered to be accommodation requests, because you're putting out your concerns to your manager about something that you are having limitations or you're experiencing limitations with at work. And so that initial request is not the end all be all, because you might have to complete some additional documentation or paperwork or something, but that is enough to trigger the interactive process between the employee and the employer. So just something to keep in mind as if you're thinking about accommodating somebody or asking for accommodations. And the employer has to respond within a reasonable amount of time. So if I say something like that today at lunch, you know, I want to be kept in the loop by my supervisor and by HR personnel as to what's going on with the accommodation. And, you know, I don't want to be left high and dry wondering, you know, 3 weeks from now, did they take my request to heart? Are they moving forward with it? So you want to make sure that you're being kept in the loop. If you're an employer, you want to make sure that you have policies and procedures in place to empower your employees, to make them feel like they're active in this process and they're involved. And you want to have those lines of communication open with your employees. Next slide. Okay. So can accommodations ever, you know, be denied? And, you know, there might be times where you might have to say this is not reasonable, but it's a pretty high threshold, right, for an employer to say that providing this accommodation would be an undue hardship. So most accommodations, about half of them are free, and then the other half are on average about $500 in cost. So cost alone is not going to show that making a particular accommodation is an undue burden, right, or an undue hardship. There's no set dollar amount, right? So there's no magic number right there. And you have to think about the overall resources that the organization has. So it's not just considering what one department or one section of a business has. It's to consider what kinds of cross-departmental resources do we have, and can we move some money around to make this accommodation work. It's also important to kind of think about how many employees, or what kind of reach does this accommodation have, and how many people is it going to benefit us, or how many people is this accommodation going to benefit. Sometimes you can actually you can purchase a piece of technology or some software that ends up benefiting more than just that one employee who's requesting the accommodation. So, and then this is kind of what gets at the heart of the undue hardship argument is it a significant, disruption in the way that business happens, right? So is making this accommodation going to fundamentally change the way that you do business? That's a really hard one to prove, because it's on the employer to prove that. And if they can't show that, then it's going to be tough to show that overall you have an undue hardship by making this accommodation. And that's why when I said earlier about documenting everything, this is important for the employer, but it's also important for the employee. Document everything. So if you can have conversations with them over email, if you must have a conversation with your employer over the phone, do it. And then as soon as you're done, sit down and take some notes about what everybody said in that conversation. And that way it's timely. You don't have to go back and remember things. It's good practice. I'll move down to the second little section of the slide, which is talking about direct threat. Direct threat basically is another kind of aspect of reasonable accommodations, right? And whether, in this case, we're talking about whether it's going to impact the safety of the employee or the safety of other employees in the work environment, in the workspace. And you need to think about whether even after making that accommodation, is it still going to pose a threat to other employees around this person. And so, that's something to think about. And this last part is what we were talking about earlier, which is that an employer doesn't have to remove any of the essential functions to make these reasonable accommodations. Next slide, please. Okay. How is an accommodation decided, right? So this is when we come back to the interactive process. It's usually initially triggered by the employee. Sometimes it can actually come from, another colleague who's noticing that this person might be having some difficulties. Most of the time it comes from the employee themselves. And it's just a back and forth, right? It's a back and forth conversation where the employee is saying, these are the things that I've been using in the past. And then, this is what works for me. And there's going to be other times where the employer might actually have some alternative suggestions that they can pose to the employee. And so it really is, it's just most important that it's a dialogue back and forth. That is the most important part of the interactive process. And, just think about it. The most expensive accommodations are not always going to be the most effective accommodations. So, that's something to keep in mind. All right, next slide, please. Okay, so can you ask for medical documentation? So the employer can actually ask for medical documentation, right, about, what this employee or about this person's disability. But the documentation has to be it has to be targeted to the job, and it has to be related to the job. And it really, like what we were saying earlier about business necessity, it's really, that is the most important thing, is how is this documentation going to prove that you can still do your job with the assistance of these accommodations. So if you are an employee, this does not mean that you go and get all of your medical records and give them to your employer. If you are an employee, this means that you go to your doctor and you get, targeted and specific, detailed, I shouldn't say detailed, but just targeted specific information about what accommodations that doctor is recommending for you and how it's going to assist you in doing your job. If you're an employer, it means that you make targeted inquiries. You don't ask to be flooded with documentation from the employee, because you want to have information that goes to the heart of this person's job duties and what accommodations they need. All the medical documentation has to be kept confidential, so only the people who have a need to know and should know about these things. But anyone outside of that, the realm of people who need to know, have no reason to be informed of these accommodations. Next slide. So who else can be told? Sometimes, if you have a smaller work environment and you have somebody whose accommodation is to have a modified schedule, it might be important that their colleagues know that they have a modified schedule. So you can let them know. You can say, hey, this person's going to come in from 10 to 6 instead of from 8 to 4. But where you would cross the line is by divulging any kind of additional information. So you don't want to say, this person's coming in from 10 to 6 instead of 8 to 4 because they have to go to their doctor every morning to receive treatment, and they need a little bit of time in the morning to do that. So you don't want to do that. You just want to be concise with the kinds of information that you need to give out to these employees' colleagues. Next slide. All right. So how can we make the process work a little bit better? So you just have to make a good faith effort, right, to provide the accommodations that actually work for the person. And you need to have if you're an employer, right, it makes life much easier if you have a centralized accommodations process and a centralized accommodations function, because this is going to be easier for the employee to keep track of where all of their paperwork is and the status as to whether they're going to receive the accommodation. And then anyone who's involved in the accommodations process, because there are inevitably going to be a few different departments within the same business that would be involved. So this would be like managerial staff, and then HR personnel, and then possibly other, colleagues who have a need to know about this. They all need to be kept, up to date. And so that's why this centralized accommodation function is going to be more effective by doing that. Employers can also have a prioritized method for the accommodations process, where the more readily available accommodations can be just implemented pretty quickly. Some of the more complex things you might have to take some time to really consider and go through that interactive process. But I think this last point is the most important one, and that is to create a trusting environment for the employees. So you want to make sure that the work environment is safe and makes the employee feel comfortable to come forward and say, hey, look, I've struggled with this, and I need to know if there is anything that I can request so that I can do my job more effectively. Next slide, please. Okay, so now we're going to get to some scenarios. These are all from popular TV shows. And this is where I kind of want to hear from you guys. So I do understand if you have questions, but you can probably ask some of these questions with these scenarios as your guidance. So Marissa, would you mind reading the first one, please?
Sure. So we have Tom Haverford. Tom Haverford, an accounts manager for the City of Pawnee Parks and Recreation Department, has long been diagnosed with a learning disability. Now, after working for the city for more than 2 years, he would like to request accommodations.
Okay, should we go to, yeah.
Think about it?
Yeah.
All right. You want me to read it through?
Oh, no, it's cool.
Okay.
I'll go.
Okay.
Talk. I'm sorry. I had to take a sip of coffee, you guys. Okay, so I wrote this question because I wanted to kind of show you guys. Can you hear me okay? The sound's okay? Okay.
Sound good.
Okay, I wanted to show you guys the kinds of, this is actually based on a technical assistance issue that I had at least, which is what kinds of documentation is appropriate for somebody when they're requesting accommodations. And so if you, I mean, because it seems like he's been working a little while, it may not be that a high school 504 plan is the most appropriate or is the most targeted. And even a GMAT, accommodations letter where it shows that that he received accommodations, that might actually be a little bit more to the point. But this last one I think is the most appropriate one because it's written by someone who has that established medical relationship with Tom Haverford. And so that might be the one that is most to the point. So it is important to think about the timeliness of the documentation that someone provides to be accommodated. I don't know if we have anyone who's raised their hand or wants to chime in on this.
I know we have questions that have come in the queue, but I think.
Yeah, we have questions that have come in the queue, but not pertaining to this yet.
Okay, then let's go on to the next one.
All right, we've got Jim Halpert, a salesperson at Dunder Mifflin Paper Company. He's a valued employee and is considered to be a rising star in paper sales. Now, Jim has several years of sales experience, but he's struggled with dyslexia since he was a child. Dunder Mifflin now requires that all sales personnel take a competency and certification exam to assess their skills. The test is 2 hours long and has 60 multiple choice scenarios. Jim often finds it distracting when people pass by his cubicle. So he's unsure of the testing conditions he will face in the break room with other coworkers going in and out.
All right, move to the
next slide.
Yeah, okay.
There we go.
So I tried to tailor this to kind of the suggestions that Julia was discussing back and forth with us, and that's to say that, yeah, sometimes, employers might have these competency or licensing requirements as part of sort of like professional advancement, professional development. And like I said, at the beginning of this, accommodations apply through all the phases of employment. And so if this is going to apply to trainings as well, right? So if somebody needs to attend a specific training offsite or through a webinar or something like that, or even on the same campus as the employer is located, the employer still has the obligation to provide consistent, reasonable accommodations, like what the employer has been doing for the employee, in their full employment capacity, right? And so when Jim Halpert needs to go and take this exam, right, like we mentioned earlier, he could just go to his manager, Michael Scott's office and say, hey, look, you know, already I deal with so many distractions of employees walking through the cubicle area. I'm going to need to be able to take this test in a private room so that I don't have distractions. He could do that. He can certainly just approach his manager like that. Like we said earlier, he doesn't have to make that request in writing. He can just orally mention that. And then if there is any additional like paperwork or anything that Dunder Mifflin has for accommodating somebody on this exam, then that would be something that they need to complete, Jim needs to complete. But that is, you know, going to be the first step, is just letting someone know that he's going to need accommodations. What kinds of accommodations? So earlier we mentioned, you know, I said that he might need a private room, he might need extended time, because like I think 2 hours to answer 60 questions is a lot for anyone, even without a learning disability. So if you're somebody with a learning disability, that could be, you know, really tough. And so he might need maybe like 50% extended time. If he has some kind of other another record where on some of his previous tests he's received these accommodations, it would be important that he just have those at the ready, just in case he does need to show that to Dunder Mifflin. But you know, it's really going to depend on how someone's dyslexia or how someone's learning disability in general affects them. And so the kinds of accommodations that they could request are they're just really varied. Next slide. All right, Marissa.
Okay, we've got Jack Bauer. Special Agent Jack Bauer, formerly a member of the FBI's counterterrorism unit for a decade, has since retired from the Bureau. So he's seeking a teaching position in various master's and doctorate level criminology programs.
All right.
Jack Bauer has attention deficit hyperactivity disorder and finds it difficult to focus on daily tasks. So he often feels overstimulated and needs extra time to perform his work responsibilities. He lands a job as a doctorate level professor in criminology.
Next slide.
So think about it.
All right. So this is kind of like just to show that, you know, there are going to be people who are at all different stages of their employment, doing all sorts of different jobs. And they, at some point, will need accommodations for a disability that they have, either at the outset or as they progress through their employment. And so, you know, what kinds of accommodations would you give to a working doctoral level professor, right? And so it might be that he needs to record remote lectures and offer them to his students if he can't focus enough to be in the classroom live for a period of time. He might have to set office hours by appointment only, and that's to ensure that he is able to get his work done and then have the full capacity or the full attention to give to his students when they do set up an appointment with him. You know, if it's something that is like affecting him in a more chronic way, or it's presenting itself more prevalently, then he might need to take some extended leave time, which is an accommodation under the ADA. And this is, ADA leave is aside from any kind of like PTO or any kind of sick leave or like a short-term disability leave that somebody would offer through their employer. This is something that's different from that, and if it's for a definite amount of time, might actually be granted to an employee with a disability. Next slide.
Sashi, we have literally about 10 minutes left.
Okay.
Would you like to skip to
the last scenario?
Well, that, or do you want to skip and allow some questions from our audience?
Yeah, that's what. Yeah. We can,
to the,
yeah.
want to skip to your thoughts, concerns?
Yes, please.
Okay, let me take us over to there. Okay, and I will let the questions come in here. Let's see.
Okay, I have actually a message from Nancy. On your first example, a learning disability documented in high school as well as extended time 6 years ago would both give an employer enough information. Someone who has had LD in, let's say, math calculation has found compensation strategies over time and would likely know what accommodations he would need from his employer. It's also unlikely his doctor would have idea of his LD or accommodations and would not be able to write any letter detailing them.
Yeah, so I completely get that. That example was just one example because I know that, you know, people with LD kind of all have different experiences, and I completely understand that. And certainly, you know, they're going to have different ways of compensating throughout their time with LD. But my point in that example was just to show that certain types of certain types of documentation, depending on the time at which they were provided or given, might be more or less appropriate than others. But I completely understand the concern there.
Okay, a next question is, are employers allowed to ask on the job application if the applicant has any disabilities?
So the thing is, you know, they can ask, right? And I think I kind of like glossed over this earlier. They can ask, but they can't condition that to as contingent, right, to offer employment. So what they can do is they can inquire, and people have probably seen this before, where they say, are you a person with a disability? And they have to make the applicant's response voluntary, right? So if the applicant chooses to answer that question, they can answer it yes or no, or any other third option that might be on there. And you know, they can leave it blank as well. So the answer to that is yes, they can. Employers can ask, but they just have to make the disclosure of that voluntary.
Great. Just a little notation someone has sent through. In your list of disabilities, you didn't mention developmental disabilities, but they're covered under the ADA, correct?
Yes, they are. They are very much covered under the ADA.
Okay. Do you have other examples of accommodations, extra job supports, or mentoring that you didn't mention?
So one that I think we link to it in the slides is the Job Accommodation Network. This is a really good resource to have for people because they have put together like extensive like packages basically on accommodation ideas based on someone's disability, based on someone's job functions, based on someone's functional limitations. They've kind of done a lot of the legwork. They don't cover every single disability out there, but they try to cover, you know, large groups, large types of disabilities to show the different ways that people can be accommodated. And then another really good tool is the Equal Employment Opportunity Commission. The EEOC is the federal agency that enforces the ADA. So anytime somebody experiences workplace discrimination or hostile work environment, things like that, the EEOC is the place to go to file a charge. And they also have a lot of different publications online about the reasonable accommodations process. And they have publications on people's rights and their obligations based on like different fields of work. So they have one for healthcare workers, one for attorneys. There's different ones out there.
Okay, we do have a question. Is there a limit on the time an earlier identifying test is valid?
An earlier identifying, what is the last word? I'm sorry.
Is valid. An earlier identifying test is valid. Is there a time limit?
I guess I don't exactly know when they refer to time limit. Are they saying like Oh, you mean like the kind of documentation that somebody is providing? I think, is that what they're saying?
I believe so, Pat. If you can clarify in the Q&A, that would be great. But it basically it
Like,
appears to be, is there a time limit? Like
like the
I'm reading
GMAT
it.
example or
Yeah,
something
or
like
if it expire, if an identifying test expires.
Gotcha. No, I wouldn't say so. But there's no like hard and fast like, oh, you know, if the test accommodation letter is from 7 years ago, that it's no longer valid. I think you look at, you know, the totality of the circumstances. So you can look at that past identifying test. You could also look at the person's functional limitations now and in the last 7 years, and put that together and understand, okay, this is what this person needs as an accommodation.
Okay, I have another question or statement. When accommodations are being discussed with your employer, you might consider having a meeting where you bring in a third party who would offer additional input or suggestions about accommodation and implementation.
Yeah, that's a really good idea. If the person who is disclosing this disability is okay with that, I would recommend that, and just make sure that that third party is well aware that this is all confidential and that they can't go and disclose the information that they discuss out to people who don't need to know about the accommodation.
Okay, next question is being a millennial a disability, coming to work on time with multiple excuses?
Well, I too am a millennial, and it's not. If you are a millennial with a disability, then that's covered under the ADA for sure. So no, but like just being a millennial by itself is not considered a disability. That's the best question I've ever gotten on a webinar. I love that.
Great. I don't see any additional questions.
This is Julia. I have one little comment to add, if that's okay.
Sure, go ahead.
I worked in higher education for 30 years with students with disabilities, and one thing that we have done before for students that we've had, because we got to know them very well and how their disability affects them, is when they're looking at a job, if they talk to us about, you know, what kind of requirements the job has, we might just write them a letter and say, hey, based on this, from what I saw when this student was my student, this young person was my student, this I think might help, you know, would be a good accommodation for them based on their disability. So sometimes people have gone back to their high schools or their colleges and requested that information. That's been really helpful in getting accommodations.
Yeah, that's a really good suggestion. Like the comment that we had earlier, right? I think Office of Disability Service personnel and counselors in the higher education setting probably have a much like more robust understanding of like what a student needs to be successful in the workplace, and so that's a really good suggestion.
This is Marissa. I have a quick question too. What about maybe a letter from the vocational rehabilitation person that someone might be working with? Would that suffice?
Yeah, that's also a good one. And I was thinking about that when Julia was making her comment is, yeah, if you have students who may be enrolled in college or they're seeking employment and they're doing employment training and things like that, VR counselors or people who have been working with people receiving VR, they certainly have a really good idea of what these students or potential employees need, and you know, and they probably also have a good network of employers who would hire this person with their skill set.
Okay, and we look to be at the bottom of the hour. We don't have any more questions. So if we want to wrap up things, I think we're good.
Thank you guys so much. This was fun.
And again, if you have any questions, the Southwest ADA Centers, their contact information is on the screen. There's also info at ldaamerica.org for any further questions, anyone watching the replay. And again, we hope to see you in Orlando at our conference, February 17th through the 20th. Sunshine in February is always a good thing. Great, thank you so much.
Thank you guys.